HT podcast, Humble Happenings. This is episode 5. We're here at 9:30 p.m. Eastern Time. Just a couple things before we get into the actual content. We are joined here by Marv, DDP, or Derek, and Rad, and they are attorneys that have decided to help us disseminate some of the information that was presented in the last filing. So we'll get into some questions for them, and they can go through an overview and whatnot. But first, we're going to go through some our mission statement. So Andrew and I, it's our mission to provide humble retail investors the latest news, filings, and happenings in the most accurate way possible and without compromise. Now, our safe harbor statement that only pertains to Andrew and I. We are humble investors. We're also part of the Humble community on Humble Social and HS2, and we are both passionate about blockchain technology. We are not speaking on behalf of Humble. We are not Humble employers or contractors. We are not insiders. We are not financial advisors. And finally, we are not compensated in any way. Any reproduction of this podcast without explicit permission is prohibited. If you are a YouTuber and you want to make some clips for your content, just shoot me a message either on Humble Social or Humble Social 2.0, and I'm sure we can figure out something. So with that being said, I'd like to have Derek come to the podium, so to speak, to talk about their disclaimers. Obviously, there's going to be quite a bit as they are attorneys. Go ahead, Derek.
The safe harbor, we're ditto for us as well. This is a specific disclaimer for those speaking tonight, not in a legal capacity, but in a capacity as people who are involved, who in the community, who are just trying to enlighten everyone the best we can. But disclaimer starting is the attorneys appearing today are not being compensated in any manner. The attorneys appearing today are not experienced in SEC law and should not be viewed as legal experts in the area of securities law. They have agreed to appear today to explain general legal terms and procedures. The attorneys appearing today do not or have not had the opportunity to review the full docket, minutes of any court appearances to date, nor any communications or correspondence between the parties to the action. The attorneys appearing today are not employees nor represent either party. They are not authorized to speak on other parties' behalf. They have not spoken to any party or attorneys involved in this case regarding the litigation in this case. The information being provided today is for educational purposes only. None of the information today is being presented as legal advice and should not be taken as such. The information being presented today does not establish an attorney-client relationship. If you are unsure of your rights, please seek and contract the services of a licensed attorney. Any information or opinion presented today is that of the individual attorney and does not necessarily reflect the opinions of any of their employers. None of the information today is being presented as financial advice and should not be taken as such. The information being presented today was taken from the public docket filings available to all and fully within the domain of the public record.
Thank you, Derek.
Thank you.
So this one's a little bit different. I know some of our podcasts have had guests like Jacob. We thought it would be pertinent for humble retail investors to understand what's happening with the lawsuit, at least in a better capacity than they understand it now. I will have content on the AFL. It was a big week for the AFL. I'll do that next week. And I think there's possibly some updates on SEC as well. However, because it's still consolidation period, it's still not much news going on from a news release perspective. We thought we'd do something special here, and we have 3 fantastic volunteers to help guide us as retail investors. So with that being said, I'm going to ask the first question to Marv. Marv, this is a class action lawsuit. Can you help maybe explain a little bit more and what that is and how it pertains to this?
Sure. Hi, everyone. It's my pleasure to be able to speak with you tonight, not in the capacity of an attorney per se, but as someone who has a legal education and understands the civil procedure part of what's going on. And a class action is just that. It's a civil procedure device that allows for one or more plaintiffs to file and prosecute a lawsuit on behalf of a larger group or a class, and the class has what's called class members. And before this can happen, the class has to be certified, and there is going to be a named plaintiff or plaintiffs. There are certain requirements for the certification, including that it is such a large group that it's too many people to be asked to join the suit as individuals. And all the people involved, including the main plaintiffs and the class members, should have a common question of fact or law, or they're claiming to suffer from the same quote unquote wrong at the hand of the defendant or defendants. And the claims or defenses of the class, its class representative, are typical of those of the rest of the class or the class members. The proposed class representative or representatives will fairly and adequately protect the interests of the entire class, and the outcome of the case is applicable to all members of the class. Therefore, individual members generally cannot then later bring their own, a case on their own behalf. The court certifies the class and defines what the class is, what the issues are, what are the defenses. And the court appoints the class counsel generally, and the court may direct appropriate notice to all the class members, at which point class members may request to be excluded, and the court will grant that request. And class members are reminded by the court that the effect of the judgment on each member is that it is binding for everyone. And the purpose of having this procedural device is that it allows for the court to manage lawsuits that would otherwise be unmanageable because there's so many people involved. And it would be difficult to have each class member be joined as a party to the suit. So it's just overall more economical, both for the plaintiffs, including the main plaintiff or plaintiffs and the class members, as well as the court, to have the matter litigated as a class action, because again, it is more economical. And, I'm not going to go into how, the outcome of any particular class action, but please bear in mind that any kind of settlement proceeds from that results should plaintiff or plaintiffs and the entire class succeed, would be distributed first to the cost of the case, and then to lead plaintiffs, and then to the class members. Generally, these cases are they are civil matters, they're not criminal matters, and they are usually brought or may be brought in either state court or federal court, or can be moved, you know, uh, on a forum by forum clauses in contracts. I'll have Rad speak some more about just the procedural aspect of this, the timeline, the forum, where the case is, where it started out, where it is now in terms of what court it is in. Rad, take it away.
All right. Good evening, everyone. Patrick and Andrew, thanks for having us on. I have known Marv and Derek from my time as an investor with HUMBL, and from time to time, we've had an opportunity to have informal discussions as attorneys regarding some of the things that have been going on. And so when Patrick approached me about possibly doing something like what we're going to do today, it was a no-brainer for me to have Marv and Derek come in. They're both very sharp, they're very knowledgeable, and they will do a very great job to assist me in my presentation. Before we get started, I took on the task of going through specifically the motion to dismiss that was filed recently. I think it was October 30th. And then just to get some more background information, I went back and I looked at the amended complaint that the motion to dismiss is being filed in response to. Keep in mind, folks, these documents are lengthy. The amended complaint was over 100 pages long. The motion to dismiss was over 40 pages long. And so while any one of those documents could give us 2 hours worth of discussion, my aim was to give you guys more of a 30,000-foot view. So you're not going to get very specific information. You're not going to get very technical information. It's basically what you're going to see from my presentation is going to be a summary of the arguments. And for the most part, everything that you're going to see in the screen that I'm going to share in the next coming minutes is going to be words that are coming pretty much verbatim from the filings. I would say 90% of the information that you're going to see on your screen is verbatim from the filings, with about 10% coming with paraphrasing. My aim is to provide factual information only. I'm going to shy away from giving any opinion. What you're going to hear today is what Mr. Pasquarelli, and if I'm saying that wrong, I'm sorry, Mr. Pasquarelli and Mr. Payson are alleging, and then what HUMBL is alleging in their response. You're not going to hear from me who I think is right, who I think it's wrong, and what the chances of prevailing in this suit is going to be. If you logged in for that, I welcome you to walk away, because I promise you that you're not going to get opinion in that form. That's all that I have to say before we get started. So let me go ahead and get the screen share going. And guys on the stage, you'll let me know if you see the screen.
We can see it.
Okay, great. Thank you. Okay, so for the purposes of keeping you guys as informed as possible, I went back, I created a very brief timeline. As you'll see, on May 19th, 2022, the original complaint was filed by Mr. Pasquarelli and Mr. Payson in the Southern District of California, that is located in San Diego. If anyone cares, you'll see that regarding the courts in California, it was filed in the Southern District. If anyone cares, California has 4 districts, which it's broken into, and I believe that is decided by the number of populants in the state. So California has 4 federal district courts because of the size of the state. Give me 1 second. Okay. Then we're going to proceed over to September 22nd, 2022, and that is when the amended complaint, which is also the current complaint, that's when that was filed. Importantly here, I found that we should note that this lawsuit covers basically anyone who bought common stock for the period of November 21st, 2020 through November 21st, 2021. Of course, that being common stock, the stock that you can buy on the open market. This doesn't cover any particular preferred shares, A shares, B shares, or now the C shares that we've recently heard about. This only covers shares that you were able to buy through your brokerage account. Okay, and then this also covers those who took advantage of the HUMBL ETX services for the period of November 21st, 2020 through February 14th, 2022. If there's anyone on the call who was not here as part of the community. Before I guess February 14th, 2022, I'll give you a brief explanation of what the HUMBL ETX was as I understand it. And it'll be outlined further in my outline. But this was a service that HUMBL provided where you paid, and my numbers may be off here, it was a while ago, but you paid $5 to subscribe to the service, and the service would then have access to your crypto trading account, and it would make trades for you, either buying or selling, depending on what the price was of that particular cryptocurrency. Okay, so let's go ahead and discuss the First Amendment complaint. Again, folks, this document was over 100 pages long. It took me about a half a day to read. So a presentation in depth would have easily gone over the hour that we've allotted to discuss these type of things today. So keep in mind that. And so I'm going to give you very, very brief information regarding that amended complaint. And that is there were 4 causes of action listed in that amended complaint. The first one was for violations of subsection 10B and Rule 5B, and that was against all defendants. What that means is that it was against the company as a company and against the individual named defendants. And I don't have those in front of me, but I remember it's Mr. Foote, Mr. Sharp, Mr. Henshaw, Ms. Rivera, and there may be others. So the first cause of action that Mr. Pasquarelli and Mr. Payson are alleging is that HUMBL made various untrue statements of material fact and omitted to state material facts in a scheme to defraud. That scheme, in turn, deceived the investing public, artificially inflated the stock price, and caused plaintiffs to purchase stock at an artificially inflated price. Second cause of action is for violations of subsection 28 of the Exchange Act, and that was against the individual defendants. So not regarding HUMBL as a company, but specifically in this count, they mentioned Mr. Foote, Mr. Sharp, and Mr. Henshaw. And the basic premise of this cause of action is that Mr. Foote, Mr. Sharp, and Mr. Henshaw were controlling persons under the eyes of the law. And under the eyes of the law, they have certain duties. And those duties included duties to disseminate articulate and truthful information. The complaint further alleges that these 3 individuals participated in unlawful conduct that artificially inflated the price. I know that I'm going on and on. Marv and Derek, if at any time you guys want to jump in and feel the need to clarify anything, please let me know. Otherwise, I'm just going to barrel through this stuff. Okay.
You're good.
Okay. Third cause of action was for violations of subsection 10B of the Exchange Act and Rule 10B-5 sub B promulgated thereafter. And those were against the individual defendants. Again, Mr. Sharp, Mr. Foote, Mr. Henshaw, Ms. Rivera, and the others. This particular cause of action alleges that HUMBL carried out a plan to deceive the investing public, caused plaintiffs and other class members to purchase securities at artificially inflated and distorted prices, and caused plaintiffs not to sell those securities until insiders sold their securities at artificially inflated prices, all through the use of misrepresentations or omissions of material fact. Now, I know that it probably sounds like I'm being repetitive, but sometimes in the law, you have different reasons to bring a lawsuit, all stemming from the same set of facts. So that is why you'll see that Mr. Pasquarelli, through his attorneys, feel that the one set of facts have caused HUMBL to, in their opinion, breach the law in 3 separate causes of action. So that's why you'll see that those things that they're saying happened fall under 3 different causes of action. It means that should this go to trial and it be resolved, they could be found guilty of 1 cause of action, the 2nd cause of action, the 3rd cause of action, or all 3 causes of action. Okay. And then the 4th and final cause of action is for unregistered offerings and sale of securities in violation of subsection 5 and 12A1 of the Security Act against all defendants. And this one just covers the blocks ETX that I talked about earlier. Mr. Pasquarelli and Mr. Payson are making the argument that the blocks ETX products are securities under the Securities Act, and HUMBL did not follow the requirements of registering the ETX with the SEC. So when, very generally speaking, when you are going to sell securities to the public, you have to follow certain procedures with the SEC, and one of those procedures requires that that the company register the company and the security, the stock, with the SEC. Here they're saying that HUMBL failed to register the blocks ETX with the SEC. Okay, so the amended complaint was filed, and HUMBL and the individual defendants then went ahead and filed a motion to transfer venue, and that was filed on October 21st, 2022. What is a motion to transfer venue, generally speaking? So you, as the plaintiff, you have the option of choosing where you want your complaint filed. In this case, Mr. Pasquarelli and Mr. Paysons, through their attorneys, decided to file in the Southern District of California. HUMBL then, through the bylaws, as I'll explain in a minute, decided that they wanted to file a motion to transfer venue and move the case from the district court in California over to the district court in Delaware. And the reason that they did that is because there is an enforceable forum selection provision in HUMBL's bylaws that we're all subject to as shareholders. That bylaw provides that the U.S. District Court for the District of Delaware shall be the exclusive forum for resolution of any complaint asserting claims under those laws. So HUMBL has bylaws that controls the company, controls shareholders, and it says that anytime that there is going to be a dispute between anyone regarding anything regarding to do with HUMBL, the forum should be or will be the District of Delaware. That is where HUMBL is incorporated as a corporation, or as a legal entity. I'm sorry, I'm not sure that they are a corporation. So that motion was ultimately heard, and on July 7th of this year, the case was transferred to Delaware, which is located in Willington, Delaware. For anyone who cares, Delaware only has one district, U.S. District Court, again, because of its population. After the case was transferred over to Delaware, there was a stipulation and an order. Basically, that is a mandate that was filed by the judge, and that was issued on September 15th, 2023. And that order ordered HUMBL to file their motion to dismiss by October 30th, 2023, which they have filed. And that is the pleading that we're going to be discussing in detail here in a minute. Now that that document has been filed, the plaintiff has the right and shall serve a response to that motion to dismiss by December 29th, 2023. So that is the next time that we would expect a pleading to be filed, somewhere around that time, unless, of course, some other legal issue pops up in the meantime. And then once that response by the plaintiff is filed, then HUMBL has the right and opportunity to serve a reply by January 29th of 2024. So very briefly, HUMBL has filed their motion to dismiss. Plaintiff gets to file a response as to why HUMBL's motion to dismiss is incorrect. HUMBL then gets an opportunity to respond to that response, to reply to that response, and say why the plaintiff's argument as to why the motion should not be dismissed, or the case should not be dismissed, is incorrect. Okay. Right, give me 1 second here to take some water. I feel like I've gone through a lot of information fairly quickly. Marvin, Derek, if there's anything that you'd like to add at this point, go right ahead.
I'll just add, just for our audience, that they understand that this is merely procedural steps that has to be taken, because a motion to dismiss, if it were granted to the party that raises it, would essentially end the suit. So therefore, each side is going to have an opportunity to try to convince the court why their argument is a better argument, really, and provide legal basis, in the case of the plaintiff, legal basis in response to what we will be discussing later in the motion to dismiss filed by HUMBL. Because when they do that, then they're, like I said, they're trying to now give counter arguments, for so to speak, to the arguments raised by the defendants.
Perfect. Yes, and I'm sorry, I didn't mention that. You know, as attorneys, we tend to, I mean, we understand the subject matter, and sometimes we get caught up in the subject matter itself and forget to add information like that. So thank you, Marv. Derek, anything you'd like to add before I go ahead and get into the substance of the motion to dismiss?
Not at this time, Rod. You're doing great.
Okay, thank you, sir. Okay, so the substance, the summary of the argument that HUMBL is making in their motion to dismiss, and again, keep in mind, these are statements that have been made by HUMBL's attorney in the pleadings. These are not my words. I just basically took everything that was on paper and tried to summarize it in a way that a average citizen could understand. So as you'll see, HUMBL's attorneys are making the argument that HUMBL did not make any misleading statements, that they made statements regarding future expectations about various business initiatives that did not turn out as they had hoped. But that is not securities fraud. Next, they make the argument that HUMBL was an early stage startup and they pursued various business strategies. Some worked, others didn't. They announced various pilot projects and business partnerships with forward-looking statements, but those were not guarantees of a particular outcome. They further make the argument that there's no such thing as a, quote, pump and pivot theory of liability. They also make the argument that HUMBL accurately stated in November and December of 2020 that they had designed and built a mobile app, not that it was an already fully functional app. HUMBL then makes further argument that plaintiff's complaint does not adequately allege that HUMBL said anything misleading regarding stock issuance or reverse stock splits. The complaint merely alleges that HUMBL omitted additional information without an explanation as to how, that was a typo there, as to how those omissions rendered accurate statements misleading. Okay. Then the motion to dismiss is then further broken down. They cover the first topic, which is that the complaint fails to state a claim under the Exchange Act for securities fraud. In that section, they make the argument that no misleading statements were made. As it relates to the app itself, HUMBL makes the argument that the app was functional, just not fully functional, as evidenced by the forward-looking words that were used, like, quote, will deliver, quote, beta testers, and, quote, pilot transactions. Those statements were accompanied by a safe harbor statement. HUMBL then also makes the argument that the statements were accompanied by meaningful cautionary language, that they did not make any guarantees of concrete fact or outcome. And they also make the argument that the complaint does not show that the defendants had, quote, actual knowledge that the statements were false. And in reliance of this argument, HUMBL makes the argument that the complaint concedes that a fully functional mobile app was realized in July of 2022. Derek and Marv, anything here?
Not at
I'll
this time.
just say,
I'm sorry, Marv, you cut out.
no,
Marv, did we
I'm
lose you?
muted. No, I'm here. I thought Derek was going to say something, so I was having him go ahead since I spoke before. So go ahead, Derek.
Marv, to cut you off is almost a sin. I don't have anything read.
Okay, Marv, anything?
The section that you're doing here, and you probably have it further, is what I want the audience to understand is that the court is going to look to whether there is a legal basis for the claims that were brought. So we're really looking to the law to answer some of these claims and some of these questions. And if one takes the time to read the motion to dismiss, they'd see a lot. It points to several case laws that set precedents to some of these areas or these legal basis for which the defendant is requesting that their motion to dismiss be granted. So that's what RAD is going through now, that the complaint fails to state a claim under the Exchange Act for the fraud, and everything from A1 to BA, all those that are listed there are some of their defense as to why they're saying this. I hope I'm making that clear for our audience.
Correct. And Andrew and Patrick, if at any time you guys hear anything as laymen who and you want something explained further or clarified, by all means jump in, interrupt me. I am not easily offended. I want to make sure that people have a good understanding of, or I guess a basic understanding. I mean,
Yeah, Rad, I
that-
just have a question around safe harbor and forward-looking statements. It's very common to have that as a disclaimer at the bottom of news releases, you know, not only for OTC stocks, but for, you know, blue chip, whatever. Are those legally binding, or is that just language to protect the sort of news release, or is that something written by their lawyers to include in there just in case?
All right, well, that's a good question. You know, I would expect these safe harbor statements to be written by a lawyer. But I don't know in this specific case if a lawyer wrote those. I mean, they are binding to the extent that you are cautioning the reader, that you're warning the reader, right? That you know, these are forward-looking statements. This is what we anticipate will happen. And of course, because it's a forward-looking statement, it carries with it the risk that these things may not happen. At least that's the argument that HUMBL is making. You know, I don't work in this area of the law, so I really haven't drafted a lot of safe harbor statements. But again, the argument that HUMBL is making is that the safe harbor statements that they had with their releases did enough to warn the reader that everything that they were seeing, it was prospective in nature, meaning that it was going to happen in the future, and that it let the reader know, of course, that because it's forward-looking, there is also the chance that these things could not work out. And then, of course, if this ultimately ends up going to trial, the judge and or jury will make a determination whether these safe harbor statements were adequate enough. Does that answer your question?
It does. Thank you.
Okay. All right, you're welcome. All right, so next, HUMBL makes the argument that statements about business relationships and prospects were not untrue. It's just that Mr. Pasquarelli and Mr. Payson wants HUMBL to volunteer information and to take the pessimistic outlook or accurately predict the future. And I guess this touches upon what we are just talking about, the safe harbor statement. So what they're trying to say here is, if I'm understanding this correctly, is that HUMBL feels like Mr. Pasquarelli and Mr. Payson are asking the court to believe that HUMBL should have volunteered information that, hey, we just contacted XYZ company. They're also a startup. The chances of us doing business together and being successful are, 10%. We don't, I guess in the pessimistic outlook, they would want HUMBL to say, we don't think that we're going to be successful in XYZ, whatever it is that they're discussing. And HUMBL says that that's not the state of the law. HUMBL makes the argument that there were statements that the company hoped would be fruitful in the future. The complaint makes no allegation that the defendants knew that these relationships would not yield the hoped for benefits. So what they're saying here is, at the time that HUMBL made these statements regarding future business relationships, they fully expected that those business relationships would pan out. Next, statements about stock issuance and dilution were all forward-looking in nature because, and this one is specifically dealing with the presentation that Mr. Sharp had, and I'm sorry, I didn't write down the date of that one, where he was talking about that they didn't, that there wasn't going to be any further dilution or whatnot. So HUMBL makes the argument that those statements were forward-looking in nature because if you read or watch Mr. Sharp's statement completely, his next statement was that they didn't anticipate before the end of 2021 to have any dilution, or I think in this particular case, it might have been reverse splits. And I haven't personally looked through the timeline, but HUMBL's making the arguments that Mr. Sharp and HUMBL kept their promise through, not promise, I'm sorry, they were accurate in their statements through the end of the year 2021. They also make the argument that Mr. Foote kept his promise not to sell shares through 2022. So here they're saying that because these two individuals said that they were going to do what they were going to do, that there were no misstatements presented to the public. Again, these are arguments made by HUMBL, and a court and or jury will decide whether those statements are correct if this case ultimately ends up going before a trier of fact, which would be the judge or jury. Next argument that was made was that the complaint fails to adequately allege scienter. And scienter is a legal term of art, which to the layman, to the general public, means intent or knowledge of wrongdoing. And then in parentheses, I wrote to deceive, manipulate, or defraud. So what this means is that, so in order to prove some of these fraud cases, you also have to prove that that the defendants knew that what they were doing is wrong, that they intended to do it, and that they intended to defraud someone. So intent, state of mind is big here. It's basically, it wasn't just an accidental action that was taken. It was taken with intent to actually do some harm as it relates to fraud in this case. HUMBL makes the argument that the complaint does not specifically state any evidence that the defendants had intent. The complaint focuses on general and conclusory allegations that the defendants were generally aware of what was going on in the company. What this means is that the plaintiff has not pointed to any specific action, or I guess action is probably the right term here, to that HUMBL did that can be conclusively taken as them acting with intent to defraud. They make very general statements, and they're very conclusory. They don't. When you say that something is conclusory, it means that you make a statement that isn't really backed by evidence, by fact. Next, HUMBL says that the plaintiffs cannot plead security fraud by citing business initiatives that did not turn out as well as they had hoped, or not come to the fruition as fast as they had hoped. I know that that may be somewhere where you have question. I don't know. This is more of a technical legal area. So if you have any questions or if you need me to clarify anything here, I'd be more than happy to do that.
So I have something here. We talk about securities fraud. That seems like something that the SEC would enforce. Why is it being brought up in something that's civil?
Okay, that's a good, very good question. So under the law, you generally have what is referred to as criminal acts, right? So, and those are generally prosecuted by government entities, right? So in the under the federal government, you would have, in this particular case, the SEC would oversee regulation of securities actions. And if the SEC if the SEC in their wisdom thought that it was appropriate to bring an action against a criminal defendant for violation of law that arose to a criminal act, they would do so. I would point out that in this particular case, this is brought by a private individual, which anyone as a shareholder or investor has the right to do, and that's the other side of the law. You can also bring civil actions against the company. So I guess this is like a checks and balances of sorts. Let's say that you as a citizen feels that the SEC is not doing their job correctly, or that they're turning a blind eye to a crime. The law gives you the opportunity to bring a private action against the company as an investor. But because you're a private citizen and not a government entity, you can't classify something as a crime. You can only make allegations that certain laws were violated. Derek and Marv, was that an accurate statement of the differences?
Yeah, I think so. Although the word fraud is used, and the first thing that comes to mind is a criminal act. So, and the question is, why wouldn't this be a criminal case? This is a civil case that was brought, and to the extent that the court or whether it's a jury or whomever hears this case finds or that there's, or actually this SEC, if this SEC looks at this case, joins in it and say, look, this company, this plaintiff, their actions were fraudulent, then that's where the criminal fix may come in. But right now it's purely civil, and that's how it's being heard.
Does that happen at all, where you start from a civil case and then law enforcement picks it up and then it becomes criminal?
You could have a defendant that goes through a civil trial. I mean, I can think of one very famous case where it was first criminal, and then that there was no finding there, and then there was a huge civil suit afterwards. So it can go either way. You can have the criminal, the civil, or civil, and then somewhere along the line you find that there are criminal actions, and it is going to be brought that way.
Okay.
Or could be brought that way,
or none of the above,
or not. That's correct. Also, bear in mind too that when you read this motion to dismiss, read the brief. They are citing case laws, and they're citing precedent on many of the issues that were raised by the plaintiff, and these case laws that they're citing the holdings from are what they're saying. Look to the court. Look, this is how the courts have ruled in situations where there are forward-looking statements, or there are omissions of omission of information that the plaintiffs bring forward, and they use the term cherry picking. You start somebody's statement and you say this is what they say, but you leave out the rest of the statement. And it's a very interesting, I find this brief very interesting. If you go back, if you had the time to sit and read the 49 pages of it, of the brief for the motion to dismiss, you would glean a lot of information from it in terms of, okay, no, this is why they're doing this, or this is what they're saying, and this is the basis for saying it. So it's not a bunch of word on paper that says, well, you should do this because you're saying we did that, we didn't do it. There are real cases out there that they're citing.
Okay, thank you for the clarification.
And I just noticed that it is now approximately 10:18, so we still have a little bit to cover. So I'm going to try to barrel through this stuff. I'm probably not going to ask for more participation from you guys unless you guys feel compelled to do so, and just ask me to stop, and I'll go ahead and do that.
Keep going.
The next, yeah, sure. So the next argument that HUMBL makes is that the complaint fails to adequately allege reliance. So it's not just enough to prove that there was fraud in the actions by HUMBL. You also have to, in order to be able to maintain a legal action, so in order to be able to be successful in a lawsuit for something such as this, you have to prove that the plaintiffs relied on the defendant's actions. So HUMBL makes the argument that the plaintiffs in their complaint do not allege that the plaintiffs relied on any particular, meaning specific, statement in making decisions about whether to buy or sell the HUMBL stock. Next, they also make the argument that in order to be able to rely on general statement, the law says that the stock in question has to be traded in an open and efficient market. Apparently, there is case law which HUMBL cites to in their motion to dismiss that says that courts have generally found, or that there's a presumption that stocks that are traded in the OTC are not presumed to be traded in an efficient market. So, in other words, if I'm understanding correctly, efficient markets would mean, the more recognized trading markets such as the NYSE, NASDAQ, things like that. Then HUMBL also makes the argument that there is no scienter, so there's no intent, there is no reliance, and then there's also no laws causation. What does that mean? As you'll see in bold, it means that the economic loss was caused by the misrepresentation. So in other words, HUMBL made statements that they knew were false. I as the shareholder relied on those statements to make a purchase in the stock. And then this third step is that because there was those statements, they caused me to buy, and it was those statements and misstatements of the law, misstatements of fact, that caused me to lose money. Okay, that's where your economic loss comes from. I lost out on my investment because of the things that you said. HUMBL makes the argument here that the plaintiff must show that the share price fell significantly after the truth became known. Disclosures by HUMBL in financial statements cannot be linked to the loss in price, because the law, according to HUMBL, is well known that at any time a company issues a periodic statement on its performance, that it is likely to materially affect its stock price. Humble also makes the argument that the complaint relies on the Hindenburg report, which was a bearish report. It was bearish on Humble's prospects. The report did not reveal any information not previously known. Its analysis was solely on information that was already public. So, in other words, what they're saying here is that Hindenburg didn't find any new information that only Hindenburg saw. Anything that Hindenburg used to rely on their report was information that was available to you, me, anyone in the public. Humble then goes on to make the argument that the claim against the controlling persons fails. As you recall, this is the cause of action against Mr. Foote, Mr. Sharp, and Mr. Hinshaw. Humble makes the argument through various pieces of case law that just because a person is a director of a company, that is not enough to show that they're a controlling person of that company. In the complaint, Mr. Pasquarelli and Mr. Payson have made no showing that a controlling person had culpable participation. Instead, in the complaint, there are general statements that they participated directly and indirectly in the conduct of Humble's affairs. Basically, what they're saying here is that the complaint just says that Mr. Sharp, Mr. Foote, Mr. Humble, and Mr. Sharp, Mr. Foote, and Mr. Hinshaw, because they were working in the company and they had knowledge of the day-to-day operations, that qualifies them as a controlling person. And Humble makes the argument that a controlling person has to be more than just that. And that is according to the case law that was cited to by Humble. Okay. Then the last argument that Humble makes, and this is where they break it up into the second section of the motion to dismiss. This covers the blocks ETX facts here. So Humble makes the argument that the complaint fails to state a cause of action in the Securities Act for an unregistered security. And I got a little ahead of myself when I first spoke regarding the fourth cause of action. So I explained more or less what Block's ETF service was, which I've done more in detail here. I think I'll go ahead and read it again. So Block's ETF, according to Humble, Block's ETF is not an asset that could be invested in. It was a software service that assisted users in trading crypto. That the crypto that the software traded were not issued by Humble. Humble didn't control that crypto. Humble did not have custody of that crypto. The way that the service worked, according to Humble, is that users paid a fee to subscribe to the use of the ETX service. That software assisted the user while buying and selling third-party crypto. The price of the crypto was not determined by Humble. The software merely made buy and sell transactions based on the price that was determined by the market. Mr. Pasquinelli was the only plaintiff to certify that he had subscribed to the Block's ETX. And in his certification, he makes it clear that he did not buy or invest in the Block's ETX. Plaintiff cannot make a case that Humble was the issuer or seller of crypto that the software bought or sold. Okay, so let me try to break that down. So Humble is saying, hey, look, we developed a software that helps you trade crypto. This is not an asset. This is not a stock. You don't buy one share of Block's ETX. Block's ETX has no value because it is not a stock. Basically, it's just a piece of software that you as the user give permission to access your crypto trading account. And then based on the rise and fall of the pricing of certain cryptos, the software would then make buy and sell transactions. Okay. So Humble didn't control the price of the crypto. Because Block's ETX is not a stock, they didn't control the price of an ETX. I mean, because it didn't have a value. I think from what I recall, it was $5 per month just to use the software. And so Humble is making the argument that because Block's ETX is software and not a stock that I could buy, and so I couldn't buy 10 block ETX shares, right? I can only pay $5 to use the block service, and then the blocks ETX service, and that service would then buy, 10 Bitcoin, 5 Ethereum, or whatever that was. That's what the service did, and that is the substance, sum and substance of the reason why Humble thinks that the cause of action for not registering the blocks ETX fails. That covers, I think, everything that the motion to dismiss covered. Only thing I'd like to add here before asking for any additional comment is that now I want to remind everyone that now that the motion to dismiss has been filed, Mr. Pasquinelli and Mr. Payson will then have the opportunity to serve a response by December 29th, 2023. And after that, Humble will have the opportunity to serve a reply on January 29th, 2024. And that brings us to date on everything that us as individuals have access to, that we've been able to look at, and we are up to date on everything that's happened in the case so far. With that, if Marv or Derek, you have anything to add, or if Andrew and Patrick, you have anything that you want to ask us, we're all yours. But the presentation is done at this point.
Red, I'd like to just thank you for that. When you're saying that that's all we have access to, that's interesting in that, everyone on the call has the ability to pull public record. And it like Marv said, it really is interesting. It mentions a lot of case law, and the case law is, the precedent in which the courts look to determine how these laws have been interpreted in the past. So it's a neat little exercise to go through and kind of understand exactly what they're talking about. But if we were to sum up, what this is, because that's a lot to throw at anyone. But we're talking about a motion to dismiss. Again, very generally stated, how Rad phrased it, from 30,000 feet. But I think it's important to mention that the motion to dismiss based on failure to state a claim upon which relief can be granted as a defense to that legal claim just basically means that the claimant, the plaintiffs, have failed. The allegation is that they have failed to present, sufficient facts in their own pleading that, if taken true, if all the facts in the pleadings were taken as true, it would indicate a violation of the law had occurred, and that they would also have to show that they're entitled to a legal remedy. So if you were to take all the facts presented in the petition, and the basic statement is, if you take all those facts for true, they still don't produce the necessary sufficiency that would indicate a violation of law has occurred, or that the plaintiffs are somehow entitled to a legal remedy. And again, this generally stated, when they rule on such a motion like this, the court, the court cannot look beyond the pleadings. It's the pleadings are what is before the court. That's the issue. That's what the court has to look at for this purpose. And the pleadings include, the complaint and the documents that are attached to it, but it's limited to that. Stated another way, when the court, deals with, these types of motions, its task is to test the sufficiency of the allegations contained in the pleadings. And in looking at that, they have to determine whether or not they're adequate enough to state a claim on which relief can be granted. So, it seems like a lot, but it's limited. And the motion spells out, at least from the defendant's perspective, based on the case law that they found, helpful to their side. You know, they spell out why they believe, you know, the plaintiff thus far has failed to state a claim on which relief can be granted. And that one standard is what's kind of being applied to all of these arguments. And again, it's public record. It's something that you can go and get a copy of. And if you know, see case law that they cite, you can actually delve deeper and pull the case and see the applicability of what they're talking about. But this is a very fact specific sort of challenge that, you know, as the facts have been included in the initial petition, you know, the motion is stating that based on all the facts presented, you know, it's, you know, there's still a failure to claim something on which relief can be granted.
Perfect. Yes. So, I mean, I think we've, I mean, Marv, I don't know. I saw you drop off. Is there anything you'd like to add before we wrap up?
No, I think, let's see, can you hear me?
Yes, ma'am.
Okay. I think you've covered it adequately, sufficiently for the time we have. And Derek just gave a nice summary on the 12B6 motion vote part of it, which is, you know, that is going to be the basis once the court examines all of the defenses that the defendants brought forward in terms of what the plaintiff is saying. You know, the court still has to make the final decision in terms of whether or not the plaintiff stated their claims are sufficient for the court to determine that there's a case here.
Correct. Yes. Okay. With that, Marvin, Derek, special thanks to you guys. Andrew and Patrick approached me about possibly doing this presentation. And like I said earlier, could not have done this by myself. Couldn't think of two people who I would have rather share the stage with. I mean, other than possibly people well-versed in SEC law, but I don't know any. So you guys are my next best option. And I really thank you for hopping on pretty much last minute, taking a look at the pleadings, and offering the insights that you guys have offered. So from the bottom of my heart, thank you so much for doing that. And Andrew and Patrick, thank you so much for having us on. To the public, I hope that when you leave here today, you have at least a general understanding of what's going on and what the fight is about. You have knowledge and understanding that you didn't have before tonight. I know that these documents are lengthy. They're tedious to go through. Even us as attorneys, it took me half a day just to get through the complaint itself. So it is very complicated stuff. I hope that I've at least given you a very basic understanding of what the fight is about, and we'll see what happens from here. As always, Patrick and Andrew, you know that I'm willing to help in any way possible. If any new filings come up and we need to discuss those, I'm more than happy to come on and discuss them. And I'm sure that, you know, I'll ask Derek and Marv, but I'm pretty sure that they'll come on and have a roundtable regarding those documents. With that, again, thank you everyone for your input tonight, and I turn it over to Andrew and Patrick. Thank you.
Thanks, Rad. Yeah, so we definitely expect you three to be a part of every single one now. If there's any updates. Yeah, we really appreciate it. You know, it's tough to understand a lot of this. We understand that now there can be a response and then further responses. That's all great. It can be a lengthy process. We know that. So thanks again. Andrew, anything to add before we wrap it up here?
No, I wanted to thank you guys for coming on board. and it was great listening to you.
Thanks. I am recording this, so I'm still trying to get the recording from the last 2 podcasts to upload to YouTube. I know it's a tough time of night for some people to hop online, but I am making an effort. Keep that in mind. We are amateurs. If you do want to connect with us, you can do it on Humble Social or HS2. You can DM us. You can add us. You can do whatever you want to get in contact on those platforms. So with that, thank you, everyone. That concludes episode 5. Thanks again to our attorneys. Take care.
Good night.